I'd like to announce that we were planning this morning on filing a motion, an amended motion to set bail and a request for emergency bond hearing. That became unnecessary because we made contact with Judge Strickland's office this morning, and they gave us an immediate court date for tomorrow afternoon at 1:30 in courtroom 6D at the Orange County Courthouse. The purpose, obviously, for that hearing is to set a bail amount for my client, Casey Anthony, and it's our position that she's entitled to a bond, and she was denied bond. The fact that she was denied bond was an incorrect ruling. In the state of Florida, I've done research as basically as much as I can. The court cited Article 1, Section 14 of the Florida Constitution, and I don't think it applies. It's our position that it does not apply in this case. She obviously is charged with a third-degree felony, a second-degree misdemeanor, and a first-degree misdemeanor. And all of the research that I've uncovered has never seen anyone being denied bail with no prior criminal history and with these set of facts. The standard bond amount, and this is just a guide for judges by administrative order, for the third-degree felony is $1,000, and normally first-degree misdemeanors are $500, and second-degree are $250. So theoretically, should the family use a bondsman in this case, they would have to post a bond of they would have to basically come up with $175 to release her. And again, this is just a guide for the court. The court can look at all facts and make their determination based on their discretion. Of course, we would just be asking for the standard bond amount in this case. Now, a lot has been made and a lot has been said about our cooperation with law enforcement, and I just wanted to clear the record, and that's really the bulk of what I wanted to speak about today. I'd like to make it clear that my client, Casey Anthony, at no time refused to speak with law enforcement. A lot has been misreported that she's not cooperating and that I am in some way standing in her way. I'd like to direct everybody's attention to the arrest report, which clearly states that the police were called out on the 15th of this month, and she spoke with them immediately on that day, and then on the following day, practically the entire day she spent with law enforcement. It's only upon being arrested and my being retained that she invoked her right to counsel, as I think anyone would do in this country. We are focused on trying to find Kaylee. And I would ask that this time, if anybody's broadcasting this, to please post her photo and not mine. We want to find Kaylee. And I have had in-depth and long conversations with my client. She is asked to help cooperate. She wants to cooperate. I, however, have to protect her. As a result of which, I sent and faxed this letter, which I'm going to give everyone a copy of, and I'm going to go ahead and read it. I sent this morning to the Orange County Sheriff's Office. Basically states, the purpose of this letter is to be clear about our willingness to fully cooperate with any and all law enforcement agencies regarding the above referenced matter. While I cannot compel or advise my client to make any statements that could possibly incriminate her, we are willing to cooperate fully with law enforcement. In the event that law enforcement uncovers certain leads in which my client's involvement can be of beneficial assistance towards finding Kaylee Anthony. My office is at your disposal. Should the need arise for immediate contact with my client, please reach me on my cell phone, which the detectives do have, so I can make myself available at any time. Please bear in mind that our assistance should be used for finding Kaylee and not for prosecuting my client. What I want to make clear, and I know there's a lot of misunderstanding about the situation, is I have a job to do, and the police have a job to do. And there's a very fine line of trying to cooperate with one another, and we're willing to put ourselves on that line to assist in any way possible of finding Kaylee. And I, unfortunately, have to be the go-between between law enforcement and my client. I will do that and on an individual basis be able to determine and make a judgment call as to which leads or what questions or so forth would assist law enforcement in finding Kaylee and at the same time protect my client's rights. I don't know an attorney in this country who would expose their client to possible criminal charges or making incriminating statements or statements that could be construed as incriminating. You'll have to remember something. People may say something completely innocent and it can be interpreted in several different ways. I have seen Kaylee's video of her walking out the jail, out of the jail numerous times, and I've heard psychiatrists analyzing it. I've heard media analyzing it. Everyone trying to interpret what's going on in her mind at that point in time. This is the exact same thing with statements, and I do this throughout every case. But this is a unique situation where we're all trying to focus on one goal here, and because of which I have to get involved. It's not because Kaylee or Casey would make any incriminating statements. It's because I have to protect my client. And like I said, I don't know a criminal defense lawyer in the country that wouldn't do the same, except maybe someone who wants to commit malpractice, and that I'm not willing to do.